Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we are approaching chapter 10, which is all about examination of witness, which is covered between section 135 to 166. That means we have to cover as many as 32 sections in this big chapter, and in that series this is my first video where we are going to cover the first section, that is section 135, which is all about order of production and examination of witness. We are going to understand how the order of production and examination of witness is done. This is a very simple section. I will give the Bare Act section. Along with that, I will also give a simple chart to make it easy for you to understand. And then I will give very important orders and chapters from CPC as well as CrPC. And finally, I have one beautiful case law to understand this particular section. Not taking much of your time, let's get into the first slide. As I said, section 135 is a very easy section which discusses about order of production and examination of witnesses. This basically covers the how part of order of production and examination of witness. The Bare Act provision says the order in which witnesses are produced and examined shall be regulated by the law and practice for the time being relating to civil and criminal procedure respectively, and in the absence of any such law by the discretion of the court. Now, when I prepare a chart for this particular section, it is a very easy job for me. Why so? It is just because the section itself is looking like a chart. The chart goes this way: the order in which witnesses are produced and examined. Now here there are two important aspects you need to observe. There is production as well as examination. Now that shall be regulated by the law and practices for the time being relating to civil procedure and criminal procedure. When I say civil procedure, it is Civil Procedure Code 1908, and when I say criminal procedure code 1973 for India. And if the law related to civil or criminal procedure is not mentioning anything about that particular procedure, or if there is absence of any practice, now in that case the discretion of the court will come to picture. The court will decide how the production, or what is the order of production, and how the examination of witnesses are done. As easy as that. Now, how is the order of production decided and examination of witnesses are done under Indian Evidence Act section 135? If that is the question, all you need to understand or answer is it is done according to Civil Procedure Code 1908 for civil cases and according to Criminal Procedure Code 1973 for all criminal cases, and the regulation as well as practices both are considered here, and court doesn't have any option here. There is very clear term shall is used, which means court has to follow according to that. And if there is absence in CPC and CrPC, if it is not mentioned in Civil Procedure Code or Criminal Procedure Code, or in absence of such practices, the court has the discretion to decide in what order the witnesses are produced and examined. As easy as that. Now there is reference of Civil Procedure Code and Criminal Procedure Code. So to help you guys what exactly we need to refer when it comes to Civil Procedure Code and Criminal Procedure Code when we are discussing about section 135, I have few screenshot slides for you. Let's get in there. As far as the production of witness under Civil Procedure Code, you need to refer two important orders, that is Order 16 and 16A, which is an amendment order. Now here under Order 16, we are discussing about summoning and attendance of witness. I have given all the orders there. You can take the screenshot accordingly. The second order, as I said, we need to refer Order 16A, which is an amendment order which is all about attendance of witness confined or detained in prisons. Here we are discussing how the production is done for those who are witnessing, who are under confinement or detained. Now this is what you need to refer as far as production of witness under Civil Procedure Code. Please take the screenshot. When it comes to examination of witness under Civil Procedure Code, we need to refer Order 18. Now here we have as many as 19 points that we need to consider, and the first point says right to begin. Who is starting the examination of witness? Under Civil Procedure Code, it is mostly the plaintiff who start the examination of witness, but there is some exceptions also. Now I am not getting into those details, but here we have very clear understanding as to examination of witness under Civil Procedure Code. All we need to refer is Order 18 of CPC to understand the same. As far as production of witness under Criminal Procedure Code is concerned, we have to refer two important chapters, that is chapter 14, which is all about conditions requisite for initiation of proceedings covered between section 190 to 199, and chapter 16, which is all about commencement of proceedings before magistrates covered between section 204 to 210. Here section 190 and 204 play a very important role, and that is as far as production of witness under Criminal Procedure Code. And when it comes to examination of witness under Criminal Procedure Code, we need to refer four important chapters, that is chapter 18, chapter 19, chapter 20 and chapter 21. Chapter 18 discusses about trial before a court of session covered between section 225 to section 237, which explains the examination of witness when the trial happens before the court of session. And then we have chapter 19, which is all on trial of warrant cases by magistrates covered between section 238 to 250. Likewise, chapter 20 discusses about trial of summons cases by magistrate, which is covered between section 251 to 259. And then we have chapter 21, which is on summary trials covered between section 262 to 65. Now all these chapters along with their sections are explaining the examination of witness under the Criminal Procedure Code. As I told in the beginning, I am referring only one case law as far as section 135U is concerned, and this is a very important and interesting case law, that is Darshan Gupta versus Radhika Gupta, which is decided on 1st July 2013 by the Supreme Court of India. This is a very interesting judgment by the Supreme Court of India. I insist all of you to read this story. And here in this particular section, I am referring the order given by Supreme Court in the year 2005 in the case of Radhika Gupta versus Darshan Gupta. Now we are referring an order given by the Supreme Court. We are reading para 6 and 7 to understand section 135U as such, which given by Supreme Court in the year 2005. The case, however, decided in the year 2013. Now for this section, we have to read para 6 and 7, which I have given here. Before I go to para 6 and 7 of this particular order, we need to understand the case a little bit. What happened here? Radhika Gupta and Darshan Gupta married in the year 1997, and in the year 1998, Radhika Gupta became pregnant. And along with pregnancy, she got a lot of health issues, and finally the child got aborted. And after the abortion, doctor very clearly told that Radhika Gupta should not become pregnant at least for another 3 to 4 years. But due to the negligence of Darshan Gupta, Radhika Gupta became pregnant again in the year 1999. That is just after 1 year of the first abortion. And this child also got birth in the 8th month and died within 8 days. Now during that pregnancy also, she had lot of health issues, and while delivering she was unconscious, and even after delivery she was unconscious. She had to go with lot of trauma in this entire process, and then after 2 or 3 years Darshan Gupta applied for divorce, saying that Radhika Gupta has mental illness. When Radhika Gupta appealed the case in High Court of Andhra Pradesh, the High Court directed that she would first give evidence on affidavit as her examination in chief and thereafter appear for cross examination. Here she wanted to give the medical examination evidence as first, but High Court didn't allow that, and that made her to go to Supreme Court. Here High Court again granted the divorce and Radhika Gupta appealed to Supreme Court, and in the year 2005 Supreme Court gave an order, and I am reading para 6 of the same, which is very important as far as section 135 is concerned. It says, in our opinion, in law, the wife has an option to decide in what manner she would oppose the ground of mental illness alleged against her. The High Court erred in directing that she would first give evidence on affidavit as her examination in chief and thereafter appear for cross examination. The proper course which ought to have been adopted by High Court was to allow her to undergo medical examination if she so desired and thereafter give her oral evidence if she so liked to do. The rigid procedure for recording evidence as directed by the High Court is unwarranted in law and particularly in matrimonial proceedings of the nature where the wife has to face charge of her mental unfitness. Here the court very clearly said the order need not to be oral first and medical examination evidence next. It could have been medical examination first and then oral evidence if she wanted to. That is what Supreme Court held here, and in the year 2013 when the judgment came by the Supreme Court, again Supreme Court declined the divorce application, saying that she still wanted to continue the maternal relationship, and you have to read the entire judgment to understand the story very clearly. I cannot explain all of them because we have time constraint here.
The plants and their leaves and their flowers and their fruits are looking beautiful because of the roots. Papa, do you want to say something?
Yes, Nishan. The outer beauty of the plant is the result of strong root of that particular plant. Just like that, the outer beauty of a human is decided by the strong character. It is not that how we look from outside. It is our strong character which makes us beautiful or ugly, which is what we need to always remember.
With that, we are concluding this section. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.